Our next case on the docket is Wakulla Fishermen's Association versus Florida Fish and Wildlife Conservation, etc. Let me ask you, why is this case any different from the other cases we've had on the net ban that has been decided adverse to your client?
Thank you. I'm glad to answer that. Your Honor, I've been involved in this for over 10 years, been here several times, and the Supreme Court of Florida. This case is different because, contrary, in all due respect to the trial court, we did not ask or advance at any time ever for approval of any particular net in this case. Never. We've suggested, in fact, we're the conservatives of the resource, and the state is not in this case. We are suggesting that the rule violates the Constitution because it endorses and, in fact, mandates, if you will, the destruction of the resource. So we're here challenging the rule and the effect of this rule. And I suggest to you, it's completely different because the only case that's really relied on by the Attorney General is the old 2-inch rule case, which went to an ALJ, and that concerned a seine net. Now, back 10 years ago, seine nets were different than today. Today, a seine net is a 500 square foot net, just like a Gillnet, but the meshes are smaller. No difference otherwise in terms of construction. And in that case, that rule was upheld based on the testimony of former Executive Director Russell Nelson and Mr. Brent Winter, an expert for the government then and now, who suggested at that time, with no tests having been conducted, that it was unlikely to be any significant impact on the resource using this net. That is, any bycatch would be negligible. But the ALJ reminded, well, let's watch how this develops. Now, since then, in 1998, we submitted independent tests conducted at the FWC, summarily rejected, refused to look at them, suggesting the 2-inch net would in fact have substantial bycatch, and that the law mandated they look at the bycatch, and they're mandated to look at the federal marine fisheries guidelines that suggest if you don't consider the bycatch, throw the test out. Throw the test out. In 2002, we did additional tests, independent tests conducted by experts, and in written form and video form, gave to the agency, again, consistent with the prior test. They refused to acknowledge we even gave them to them. So in 2005, the agency met with representatives of the Wakulla Fishermen's Association and suggested, okay, let's do some joint tests, and we'll agree to be bound by them. The nets were constructed by the fishermen under the specific control of the agency. 2 500 square foot nets, one 3-inch mesh, one 2-inch mesh, to determine the effect of those nets in the water. They were deployed in 3 different locations, many times over several days. And then the agency said, whoop, no more tests, stop them, we're not going to do them. The test showed, Your Honors, that in the 2-inch net, over 70% of the fish caught were gilled. The important factor is, of all the fish that were caught, that were gilled, over 90% were illegal, undersized mullet, that you gill them, they die, they can't reproduce, and that will harm the resource. The Supreme Court told us in advisory opinion, the singular sole purpose of the amendment is to protect the resource from unnecessary and wasteful killing of the resource. Now,
Mr. Mayor, let me stop right there a second. Now, it seemed like the trial judge was saying, in reference to the complaint, be careful what you ask for, and it seemed like you're asking for a declaration that the 2-inch net be declared illegal. Wouldn't that put your clients out of business if that occurred?
And I thank you for asking me that. There's nothing in the Constitution that says anything about mesh size. That's a matter to be determined based upon the best information available. The agency is required to follow 370.025 and federal guidelines as well to establish what's best. Maybe a variable mesh net is used. Maybe different times of the year, different seasons, the mesh size may change. But no, Your Honor, out of all due respect, she misconstrued what we are arguing. We're suggesting, as the Supreme Court said, only a net that's a gill net that unnecessarily kills and wastes fish is prohibited. And it's a violation of Article 10, Section 16, and also Article 1, Section 7, which tells us protect the resource. Now, if you look at the comparison of the two in the test conducted, if you look at the 3-inch net, you'll find that substantially less were gilled, and of those, the vast majority were in fact legal fish. Legal fish. The net result of this test is that if you're going to fish, the law says you're a mullet fisherman, you use a 2-inch seine net. A seine net, by definition, under the rules, is a net that does not gill. This net gilled over 70% of the fish it caught, and out of the 70, over 90% were illegal fish. The net result of that is, in a 2-inch net, to catch one legal fish, you catch 14 illegal fish. Repeated many, many times in the test conducted with the agency under their rules. The net effect of that is, if you take the 45 million pounds of mullet caught, landings, and from 99 to 03, to catch that 45 million pounds of legal mullet, you would have caught 630 million pounds of illegal mullet. I suggest to you, the evidence is, from the state and the federal reports, the resource is declining every year that's caught, and the same number of fishermen is not declining. So in the summary judgment hearing, the question was there substantial facts, material facts in dispute? Rational basis is not real strong.
Counsel, the appellants filed a motion for summary judgment in the trial court.
Did
the appellants file a motion for summary judgment?
Yes, Your Honor, we did.
Did the appellees file motions for summary judgment?
Yes, sir.
So both parties were contending in the proceeding below that there were no disputes as to any material fact.
That's correct.
Is that correct?
That's correct. As permitted under the Rule of Civil Procedure, you're right, for that purpose.
Okay. Were there any traverses filed to the motions for summary judgment? Were there any traverses filed to the cross motions for summary judgment?
Yeah, we filed 3 affidavits in opposition to the motion for summary judgment, which suggested, and I also filed copies of the transcript of their expert, their only expert who dealt with the material issue, that is, the effect of using a 2-inch net on the resource, Brent Winter. And Brent Winter's testimony in his affidavit's one thing, but look at his, and I cite...
So is your position on appeal that there were material issues of fact before the trial court?
There were substantial material issues of fact that prevented the entry of a summary judgment order in their favor. And it's based upon their own evidence that there's no rational basis, because their own expert said in a deposition, if there is a substantial bycatch, that's not good for resource protection, contrary to his opinion 8 years ago in the 2-inch rule case. So my point is, we both filed cross motions. We opposed theirs with affidavits, with experts of longer and more experience than their experts. I think they clearly created issues of fact. So you may be asking me, well, why would the judge have granted summary judgment either way? We were shocked that we thought she would deny them. She would grant ours or deny theirs or deny both. Never, ever would she grant a motion in their favor, not based upon the fact. The only, other than having an expert say, other than saying, well, they have an expert who said it's okay. If you look to the material part of his affidavit, it's inconsistent and does not support the rule. It does not.
Now, both the 2-inch nets as well as the 3-inch nets gill fish. Is that correct? Both?
That's correct.
One maybe less than the
yes,
other.
Your Honor.
Well, then, is your argument before the trial court pursuant to Article 10, Section 16 of the Florida Constitution, any rules permitting the use of any nets that gill fish are unconstitutional?
Well, it depends only if it's a gill net. But what makes it a gill net? The definition says any net that gills. But, I mean, it's like when you're raising your child, you can say, go do what you want, I don't care, or no, you can't go. What's in the middle? You've got to find that rule that allows a reasonable use, if you will, collection or catching of the resource and protection of the resource. No, it's not a ban. It means it's a tougher question. There is a way between the two to find the net that, in fact, will allow a reasonable harvest of the resource and protect the resource. But you can't say that or 3-inch nets of Gillnet based upon the three-pronged test of the agency. That is, how do you construct it? How do you use it? What's the resulting catch? If you do, you apply it to the 2 and the 3. You can't use any of them.
Mr. Bauer, are you going to save this time for a rebuttal?
Yes, sir.
I don't remember.
Yes, sir, 3 minutes.
And you're getting close, so I wanted to help you out there.
I'm gonna stop right now, Your Honor, and I'll rebut. Thank you.
All right, you got 3 minutes for rebuttal. Here for now, please.
Good morning, Your Honors. May it please the Court, I'm John Glogow on behalf of the Fish and Wildlife Commission. Your Honors, I find myself standing at this podium for the 6th time arguing a case involving the question of what is the proper definition of a gillnet under Article 10, Section 16 of the Constitution.
Well, Counsel, aren't you here facing a case where they're saying that the 2-inch net is illegal, and in the past they were trying to affirmatively get a ruling that a 3-inch net was legal, and isn't that a big difference between this case and other cases?
No, Your Honor, because the question before the Commission is, as Mr. Mowery sort of said, and as the Court seemed to be going in that direction, and the question is, all nets gill some fish, and the Constitution, everyone understands, was not meant to ban all nets, only gill nets. So the question for the Fish and Wildlife Commission and the Marine Fisheries Commission before that is, how do you tell the difference between what's prohibited and what isn't? And in the exercise of their judgment, they determined, based on the historical use of nets, based on the advice of their experts, that the 2-inch mesh rule would be a reasonable place to draw the line. The question of material fact that the appellants are trying to argue here is not really, I suggest, a question of material fact.
Counsel, they're saying that 2-inch net gilled about 90% of illegal fish, and the 3-inch net gilled much fewer of the smaller fish, and that 2-inch net adversely impacts the environment. They've got experts to say that. Why didn't that create a genuine issue of fact that should have been heard by the trial judge rather than on summary judgment?
Well, first of all, as to the 3-inch net, Your Honor, the court, this court, in the appeal of the rule challenge, said this, that mullet nets that would be prohibited by the proposed rules, that's the 2-inch rule, can take mullet in a commercially viable manner only when used as gill or entangling nets. There's no question that the hearing officer and this court determined that the 3-inch net is a prohibited gill net. So now the question is, what is the 2-inch net? First of all, the plaintiffs say that they're going to annihilate the species using the 2-inch nets. The hearing officer in paragraph 55 of the order, back on the rule challenge, said, quote, no dangerous level of unnecessary killing or waste will occur, and the rule will enhance the overall fish population recovery effect already in progress.
Well,
and in fact, Your Honor, if I may finish, in fact, the undisputed statistics that were provided in the summary judgment motion bear this out. 45 million pounds of mullet were landed between 1999 and 2003, and the population is healthy and getting healthier every year. So there is no disputed issue of fact here. The only dispute here is their assertion that...
If I might ask a question.
I'm sorry.
I would like to know if the evidence that's been presented to the trial court was presented at the time the ALJ entered the ruling that you just quoted to me.
The specific test that they're talking about was not, but there was evidence and opinion testimony presented to the hearing officer that allowed her to make those determinations. In paragraph 37 of the final order, the hearing officer says, in formulating the proposed rule, the commission was presented with extensive comments, technical information, and post-amendment updates of earlier surveys. The specific evidence was not presented. Of course, it wasn't generated until last year. But
why shouldn't it be considered when you get better data, and newer data, and as I understand, your client agreed with the appellate to go out and test these nets, and when the results appeared to be adverse to your client's position, then the tests were terminated. Is that a
That
fair
is not,
description?
absolutely not what happened, Your Honor. Those tests, the information that was gleaned from those tests was exactly what the agency expected. They knew that the 3-inch net would gill legal-sized fish, and they knew that the 2-inch net was going to gill undersized fish. But
Excuse me. Now, we're not going to have any talking out from the audience, and we'll clear it if we hear it again. Proceed, please.
the key issue here, Your Honor, is the agency's judgment that gilling, number one, would not have an adverse effect on the population as a whole, a conclusion made by the hearing officer in 1997 and borne out by the data, undisputed data, today as to the health of this population. And secondly, Your Honor, it's based on a misconception. The rule does not require the use of a 2-inch net. 2 inches is the maximum. If they're gilling undersized fish and making it uneconomical for fishermen to use a 2-inch net, they can reconfigure their net. They can use smaller mesh size. As we say in our brief, in Texas, they limit them to 1 inch, not 2 inch, but 1 inch. Or they can use thicker twine. That's what the affidavits that we presented indicate, to decrease the gilling characteristics of that 2-inch net. So therefore, it is not economically reasonable for a fisherman to go out there and whack the undersized fish. They're not going to do that. Secondly, most of the mullet are caught, and this is all in the affidavits, and it's uncontested in our affidavits. Most of the mullet are caught during the roe season. During the roe season, the juvenile mullet do not school up with the breeding population. So when the breeders school up and get ready to go offshore, which is when they get caught, there aren't a bunch of juveniles swimming with them. So it was the considered opinion of the commission that allowing the use of the 2-inch net is not going to hurt this population, and that's exactly what the uncontested statistics show. The population is healthy, and it's getting healthier all the time. Your Honor.
Well, Counsel, I thought there was some expert testimony in this record that said that the 2-inch net was counterproductive and it would hurt the production of fish. I believe it was a Jack Rudlow,
well, Your Honor,
who was an expert, and he testifies by affidavit contrary to what you state here. And I don't know who's right or wrong, but isn't this something that the trial judge should hear at an evidentiary hearing rather than on summary judgment? That's sort of what bothers me now, how the trial judge could decide all these things on a summary judgment and not have an evidentiary hearing.
Well, Your Honor, first of all, I'm sorry. First of all, we're dealing with the rational basis test here. We have a constitutionally created agency, and the appellants don't argue with the fact that we have to use the rational basis test. And so what the trial court determined was that if the agency presents a rational basis for the rule on the record, then that's all they have to do, and that's what we did. The second thing is that under the Hare case, coming in with an expert just to say, I don't agree with his expert, is not sufficient. All Mr. Rudlow's expert opinion really is a disagreement with the wisdom of the agency's decision. And that is, as the court said in Hare, that is not a disputed issue of material fact, but rather, I'm sorry, I got too many pieces of paper here. Anyway, that is an argument about the wisdom of the legislative choice. Oh, here it is. What we have here is not a disputed issue of material fact. The trial court properly decided, Your Honors, I believe, that this is not a disputed issue of fact, but as in what the court said in Hare, is that this is a debatable question about the reasonableness of the commission's decision. And it's not for the court to debate the wisdom of the legislative determination, or in this case, quasi-legislative determination.
Well, let me ask you this, Counselor. Can your commission just do anything and we have no supervision over it, even if it's totally unreasonable, which Mr. Rudlow says it is?
No, it's not
Well,
totally.
it is a question here where we draw the line in the courts as to whether a rational basis is presented or not. And as I understand, Mr. Rudlow, he's a marine biologist.
No, he's not, Your Honor.
He's not? Okay.
No, he's not.
All right. Well, he's got, what kind of experience has he got?
He runs a specimen lab out in Panacea and has written a couple of books that are not real scientific books.
But wouldn't that be something that you would flesh out at an evidentiary hearing rather than by affidavit? And didn't he say that he thought that the 2-inch mesh was a menace to the resource and would eventually destroy it by killing off all of the juvenile fish?
But, Your Honor, the uncontested statistics that are in the record here show that what the hearing officer found 7 years ago is borne out. It was found that the 2-inch net would not, and Mr. Rudlow testified at that hearing too, and he said the same thing in that hearing. And what the hearing officer found, as I read to you before, was there would be no unreasonable amount of unnecessary killing, and it wouldn't hurt the resource. That's what our experts continue to say. That's what our affidavits continue to say, and that's what the statistics bear out, Your Honor. That's the key thing here. This has been litigated. It was litigated in 1997.
All right, let me ask you right there, has it ever been litigated that the 2-inch mesh net is illegal, as they're saying today? Has it ever been litigated in that respect?
Well, what was litigated was whether the choice of 2 inches was reasonable and not arbitrary and capricious. And it was found that it was, and this court affirmed that decision. This court affirmed that decision and said the 2-inch mesh rule, it's the same rule. It is the affidavits that we presented from Julie Jones, who's a colonel in the Marine Patrol. The rule is exactly what it was back then, 2-inch mesh. And that was what was being tested in the administrative proceeding. The administrative proceeding, was found that net rule complied with Section 370.025. It complied. They made, the plaintiffs in that case, Your Honor, made exactly the same claim that they're making here. Paragraph 65, the hearing officer says, petitioners challenge the proposed rule because it will allegedly cause unnecessary killing, overfishing, and waste of juvenile fish. That is exactly what they're saying today, and she discounted that. She said that's not correct. The rule is valid. MFC's, paragraph 78, Your Honor, MFC's determination that nets comprised of greater than 2-inch stretch mesh constitute gill nets is not arbitrary and capricious. The selection of 2 inches in paragraph 76 was historically based, rational, and practical. There's no dispute here, Your Honor, that the agency's decision that 2 inches is the bright line demarcation between what is legal and what is not under Article 10, Section 16 is rational. It's not arbitrary and capricious. It will not hurt the resource. It hasn't hurt the resource. It's been in effect for 8 years, Your Honor, and the resource continues to get healthier.
Counsel, let me ask you this. Does the 2-inch net gill or capture, I'm not a fisherman, 90% of illegal fish? When they ran those tests,
when they ran the tests,
yeah, what happened?
I don't know the exact numbers, Your Honor, but that doesn't sound out of line. 90% of the fish that were gilled.
That's what Mr. Maurer just
well,
said.
I'm not questioning his that. I mean, 90% of the fish that were gilled were juvenile. But the point is, Your Honor, that first of all, it makes no.
All right, let me stop you right there because I want to make a point. 90% were juvenile fish, which we say were illegal. You couldn't take them, couldn't harvest them. All right, what percentage did the 3-inch net do to accomplish? What percentage did they get?
Forgive me, Your Honor, I don't know. It's about, what was it, 70% or something were legal?
Given that fact, if it is a fact, counsel, that the 2-inch net gills more juvenile fish than the 3-inch net, what's the effect of the 2-inch net on the mature fish, and what's the effect of the 3-inch net on mature fish? Is there any
Well,
evidence to the record concerning
the
that?
effect of the 3-inch net on the mature fish is that they get gilled in it, and that makes it a gill net prohibited by the Constitution. All of these cases say that. The effect of the 2-inch net on the juvenile fish, as the hearing officer said in 1997, and as borne out by the fisheries statistics that are in the record here, is that it doesn't hurt the population. And the reason is, as I said before, it makes no economic sense to go out there with a 2-inch mesh net and do that to the juvenile fish. Secondly, Mr. McCrae's affidavit says very clearly that the taking of juvenile fish in the 2-inch net is less damaging to the resource than the directed harvest of the mature fish in the 3-inch net. And the reason for that...
Is there any material fact in evidence that is in conflict with that assertion?
No, they have not. There's a lot of... if you read their affidavits, Your Honor, you will find that they're all in the nature of, I am aware that, or I think, or somebody told me that. Mr. Rudlow's affidavit, if you read it, it's very clear that what he is saying is that he disagrees with the 2-inch net. He says very clearly, the 2-inch net violates the Constitution. The 2-inch net should be repealed. The 2-inch net does not have a rational basis. That's not disputing a material fact. He just disagrees with the rule. And the wisdom of the rule is not something that he can disagree with and create a disputed issue of material fact. That is a debatable question of reasonableness, which is up to the agency to determine, not for the court. And so there was no question of material fact. It was the rational basis was evident on the record, and since the rational basis for the rule was evident on the record, it was properly granted. We were properly granted summary judgment. I see I've run out of my time.
Well, you want, we've given you a hard time. Well, if you'd like to have a minute to wrap up, we'll add another minute or two to Mr. Mowry's time, so it'll be fair. Would you like to wrap up? I mean, you have had to.
The only thing I can say, Your Honor, is that this is an issue. The question of where the Commission should draw the line between what is legal under the Constitution and what is not has been litigated over and over again, and the decision to put the line at 2 inches has been found over and over again to be reasonable, practical, rational. And the undisputed statistics show that the resource is not being annihilated as alleged by the plaintiffs, but is in fact getting healthier under the Commission's rules. Thank you.
We'll add 2 minutes and 7 seconds to the appellate's rebuttal time.
I learned a long time ago when you're through, you need to sit down. So when I get through, I hope I sit down early. But let me respond.
I doubt you will. But...
Thank you. By saying a few things. I appreciate the position of the Attorney General's office in this case. But this is totally different. And Judge Bunny, I believe you're right on point. What happened in 95 is not what happened in 2005. It's 96, 97. It's vastly different because even their own expert has changed his testimony. He suggests now and agrees you must consider the bycatch. Back in that hearing, the finding was the testimony of Mr. Brent Winter and Mr. Russell Nelson was that less than 5% of the fish caught would be bycatch. 5% max. Now we know it's 90%. Is that a problem? That's a serious problem for the resource. Mr. Rudlow was prepared to testify in great detail about his 40 years of experience in the marine fisheries industry and as a marine scientist. Knows full well has used hundreds of these nets hundreds of times. In fact, applied for a special grant years ago to be able to conduct some tests, was rejected by the agency. I suggest in addition to Mr. Rudlow, look at what Mr. Paul Johnson said, which deals with the very tests conducted. We didn't cancel those tests. We wanted to keep doing the test. I use that term loosely, we. The agency canceled those tests thereafter. I suggest...
Opposing counsel said this is exactly the same claim as the proceeding he was quoting from as precedent. Would you address that point and enlighten me a little on
You mean
that?
This is the same as with the 2-inch rule challenge? Yes, sir. No, Your Honor, it's absolutely different. And again, it goes right to the heart of the issue, and that is, back in 1996, the amendment was brand new. No tests had been conducted back then. Nobody knew the real impact of this net, of using a 2-inch net. Nobody knew that. And there were no tests conducted, no testimony of any test conducted when they testified in 96. And the only testimony was the bycatch would be negligible, 5%, with a warning, in the future we need to watch that. Their own expert, in his deposition, before his, or at the time of his affidavit, suggested, if there is unusually large bycatch, that's not good for fish resource management. That's a problem. We'd also proffered a deposition of Mr. Jack Forrester out of the Federal Marine Fisheries Agency, and for some reason was directed by his superiors not to sign the affidavit. But his proper testimony was, clearly, this 2-inch net will destroy the resource. Short and sweet, nothing to the contrary. So, Judge Lewis, in response to your concern over the issue of move across summary judgments, there's nothing fatal about that. That's a procedural exercise everybody does when you file these. Doesn't mean we acknowledge anything except we thought clearly the court would look at the facts most favorable to us. With our affidavits, it was clear the rule violated the Constitution in terms of Article 10, Section 16. It violated the due process because it tells us to go use that net. And I've defended tens of these cases in many counties. You use that net, you gill fish. They may have a policy that says, and they discussed it in their position statement, that, well, if that 2-inch net gills fish and it's only incidental, we're not going to arrest you. You can't enforce an agency policy. What's the rule? What's the law say? The law says if a seine net does not gill fish. Doesn't say some of the time, it says it does not gill fish. If you do, you run the risk of losing your catch, your nets, money, your license. It's a criminal offense, and substantial penalties on top of that. In addition, the clear position and opinion of the Supreme Court of Florida was that you protect the resource. Article 10's sole primary purpose is avoid the unnecessary killing. And if we've not shown sufficient evidence to go to an evidentiary hearing to establish that, we never will. This, whatever they think they are, this constitutional unknown over here agency that suggests basically, and I think the court kind of felt like nothing I can really do if they say there is a basis, I kind of have to accept it. We don't agree with that. We're entitled to some due process here. We're entitled to a hearing in circuit court, and they acknowledge that. But we never get to a evidentiary hearing. I was troubled, if I might say this very candidly, in an early hearing with the trial court in discussing a scheduling conference, that a comment was made by the court that I should anticipate the state's going to file a motion for summary judgment that will likely dispose of this case. I mean, I almost fell out of my chair when I heard that. So obviously we moved to recuse the judge.
I think you're going to have to get in your chair. You're out of time.
Okay. Well, thank you, Your Honor.
Thank you. That